Good afternoon, everyone. We're here for the June 29th meeting. We're very proud to have the new clerk of the court here, and I'll have Judge Delano present her to everyone. So I'll go ahead and turn the floor up to Judge Delano. Thank you.
Hello, good afternoon, everyone. Nice to see you all. In just a moment, I'll introduce you to our new clerk, but I wanted to just give you an update on a few things first. I think you all probably got an email a couple of weeks ago about a Judicial Liaison Committee meeting in Tampa to discuss Chapter 13 fees and the reasonably presumptive fee that is presently the system in here, both in Tampa and in Fort Myers. So there's 2 points that I want you all to keep in mind. And first is that reasonably presumptive is just that. It doesn't mean you can't, in any case, file a full fee application if you want. And in many cases, it's warranted. Sometimes in a Chapter 13, the attorney might have a lot of litigation with the IRS or on a claims objection, or a motion to strip a lien might end up going to trial. And in those types of cases, it might be appropriate to file a full fee application. Many of you probably keep time, concurrent contemporaneous time records, and maybe you do that already, and then it's not too hard to pull together a fee application. But I think there's probably a large number of debtors' attorneys that just are looking at the fee as being a flat fee. So it's not really a flat fee. It's a reasonably presumptive fee that means that the court or the trustee is not going to have a problem with the fee as long as it doesn't exceed the reasonably presumptive fee. The other point that I want you to keep in mind is that just because a fee is reasonably presumptive doesn't mean that you need to charge it. So you might look at a case and say, well, this is going to be a really easy Chapter 13. I'm not lien stripping, I'm not doing mortgage modification mediation, I'm not going to have any claims objections. All I want to do is pay an acknowledged IRS claim, and we're just going to put a plan together and get it confirmed. And that's not going to be that hard, and so you're not going to charge your client the full amount of the reasonably presumptive fee. So that's something that you just want to kind of consider, and obviously market forces also sort of come to bear in terms of there's competition in the workplace, and then perhaps some attorneys charge less than other attorneys, and that's obviously your decision. So you all know that we've been working under this reasonably presumptive fee schedule for a number of years now here in Fort Myers and in Tampa, that lays out what the base fee is for a Chapter 13 and provides for an a la carte menu of various different items that if you do one of the items that's on the list, you can charge $300 and $400 if there's a hearing. And that a la carte menu has created some frustration, I think, for judges and probably for practitioners as well. Because sometimes the attorney does something that's not on the a la carte menu, but still it's been extra work and the attorney wants to be compensated for it. Gives the judge a real dilemma. Do I allow it? Do I not allow it? Sometimes in a relatively simple case, the a la carte menu items can run up. And you might be looking at a case where maybe over the course of a 3 or a 5 year plan, there were 6 or 7 miscellaneous motions filed. Sometimes those motions are 2 sentences long. And you look at it and it's like, oh my gosh, it ended up being an extra $1,800, an extra $2,100 in the case. And was that really reflective of the time that was involved in filing those motions? So that has been kind of a concern that's been percolating with the judges and I think the trustees for some time. Another issue that's been percolating for some time is an awareness that in Jacksonville and in Orlando, there are different fee structures and different presumptively reasonable fees, and that perhaps the lawyers there are making more money than the attorneys in Tampa and Fort Myers. And no one would ever concede that the lawyers in Jacksonville and Orlando are more talented or more effective or do a better job than the Tampa and the Fort Myers lawyers, who I will say are the finest lawyers in the country. So that's been kind of an issue. So you all probably know, and I think you probably all do, and some of you have been invited to attend, and if you ever are interested in attending, let me know. But every year for the past 3 or 4 years, I would say, Judge Gentleman started this practice on the night before the view from the bench or the afternoon before the view from the bench seminar, having a bench bar conference. And there would be different topics that were discussed at the bench bar conference. And this last year, there was a discussion about Chapter 13 fees, and it takes a long time for these issues to percolate their way through judges' meetings. But the judges have been talking about it kind of more and more. But there was, kind of a general dissatisfaction, I think, among the Tampa and the Fort Myers practitioners regarding the amounts of the fees. So a week or two ago, there was a judicial liaison committee in Tampa, and the discussion was Chapter 13 fees and should we go more towards the Orlando and the Jacksonville model. I'll also tell you that in Orlando and Jacksonville, and I'm sorry we don't have anyone from the Chapter 13 trustee's office here today, that in Orlando and Jacksonville, the trustee really takes a lead role monitoring the amount of fees, and only if there's an issue does the judge ever really get involved. But the Orlando model was this: $4,500 through confirmation, and then $50 a month monitoring fee from confirmation until discharge to cover whatever comes up during the case. And between $1,800 and $2,500 for mortgage modification mediation, depending upon how complicated it was. Now, compare that to the fees that we're allowing in Tampa as reasonably presumptive fees in Tampa and Tampa and Fort Myers has been $38.75 for a plan that's 36 months or less, $42.25 for plans of 60 months. So right off the bat, an Orlando lawyer's getting $275 a month just in the base fee, and then the attorney's getting $50 a month for the post-confirmation monitoring. Well, you think about it, the sooner you get to confirmation, the better off you are. And if you get to confirmation, let's say in 6 months, well then you've got 54 months at $50 a month, which is a pretty significant fee, and will compensate you for the time that I know you all spend dealing with tax returns and things along those lines, following up with the Chapter 13 trustee's office and dealing with miscellaneous motions. So there was sort of a discussion. There were representatives at the meeting. All of the bankruptcy trustees were there from Tampa and Fort Myers, Mr. Waggy, John Waggy, and Kelly Remick. Lori Weatherford from Orlando came over. Doug Meway was on the phone. Actually, he was on Judge Williamson's iPhone in the middle of the table talking to us. And poor Doug Meway, he's invited to this meeting. Little did he know, the first words out of Judge Williamson's mouth are, and Doug, could you give us a little overview of the way these things are handled? He had no idea he was like the centerpiece of the discussion. But anyway, he launched a discussion. And it was really very helpful. And in addition to the trustees being there, and the United States trustee, there were 4 or 5 practitioners from Tampa, just debtors lawyers, that all had opinions on how this should be done. And of course, I had sent out an email that Ryan's office was nice enough to forward to everyone asking if anyone had some input, and I did get some input from 3 or 4 lawyers. So the consensus at the meeting was that the Tampa lawyers would like to go to the Orlando model. Generally, under various scenarios, the Orlando model would typically allow for greater attorney's fees than what is commonly allowed in Tampa and in Fort Myers. And so then the Tampa judges, we all met this last Monday and had a discussion, and that's pretty much the agreement that we've come to, is that starting, and I can't tell you when, but soon, starting soon, it's going to be a reasonably presumptive fee of $4,500 through confirmation, $50 a month monitoring fee until discharge, from confirmation to discharge, and then the standard $1,800 for mortgage modification mediation, unless it's a complicated issue, and then you should file a fee application. So this is all coming to fruition at the same time as we're trying to finalize our new local form of the Chapter 13 plan. I think you all have heard and probably heard me talk about this already, how under new bankruptcy rules, there's going to be a national official form, and if districts want to opt out, then they have to post a local form for public comment, and the local form has certain requirements that have to be included, which required a few tweaks to our model plan form, and we're in the process of finalizing that. There was a goal of having it posted for public comment on July 1st, just because of some people's travel schedules. I think it's going to be a little bit later than that, but it'll be posted for public comment for about 30 days. I have to tell you, if you have a comment, please shoot me an email, because the work that we've been doing on the plan is judges and the trustees, and we're looking at it from one perspective, but you all are doing the actual work. You know, you're the feet on the ground, and so if you have any issues, please let me know. But we're really trying to simplify the form, trying to make it a little bit more clear both to the attorneys, even more importantly, I think, to the pro se's that are filling out these forms themselves, and try making the process easier for everyone. So I hope that you all will be happy, or the Chapter 13 practitioners will be happy with the new fee structure. I think at the end of the day, it's potentially greater compensation for the cases. We are going to be meeting with the Chapter 13 trustees, and I mean the judges and I are going to be meeting with the Chapter 13 trustees to talk about some procedures that will possibly streamline the cases. Obviously, it's to every Chapter 13 debtor's attorney's best advantage to get a case confirmed sooner rather than later, because then the $50 a month monitoring fee kicks in. So if you confirm a case in month 6, that's a lot better than confirming a case in month 24. And I don't really have a good feel for the statistics, because I know that on the confirmation calendar, many cases are read in, there's no objection, and they're confirmed without an objection. And I don't see those cases, and I don't know what those numbers are. I feel like every case that I see on the Chapter 13 calendar is 12 to 24 months old. Now, that doesn't mean every case is 12 to 24 months old, but there's a lot of cases that are 12 to 24 months old. Well, if a case isn't confirmed until month 24, well, that's 12 or 18 months of monitoring fees that are just not going to be available for debtors' counsel. So there's an incentive to get that done sooner rather than later, get to confirmation sooner. One thing that I think we need to be looking at a little more closely is whether it's necessary to wait until a mortgage modification has been finalized prior to going to confirmation, or does it make sense to confirm while an MMM is pending? That is sort of the Orlando model, and that might be a better way of doing things. One thing that has really helped us in this analysis is that Judge Colton is hearing Chapter 13s in Tampa and hearing Chapter 13s in Orlando. So she has a perspective on seeing different ways the trustees handle cases in both jurisdictions, and different types of motions that she's seeing. The other issue is that I think I just want to preview for you, and it's a little bit unfair of me because it hasn't been previewed with the trustees yet. But there's a kind of a practice, I think, of when the debtor defaults in plan payments, the trustee files a motion to dismiss. Automatically an order reserving ruling is entered, which provides for the debtor to make the next 2 plan payments on time and then to cure with the 3rd plan payment. And one of the problems, I think, is that that order then allows for a dismissal of the case, for the trustee to submit an order dismissing the case if there's a future default. Maybe there's notice to the debtor of that, maybe there isn't notice to the debtor of that. That ends up prompting a lot of motions for reconsideration or motions to vacate dismissal orders. And evidently that's not an issue in Orlando. It just doesn't happen quite the same way. So the goal should be to keep your debtor in a Chapter 13 case, and if the debtor's not going to make it in the Chapter 13 case, maybe it's better to let the case be dismissed and move on with another case. But that's something that we all need to talk with the Chapter 13 trustees a little bit more about, and talk about those procedures. Hopefully there's not a lot of post-confirmation work that ends up having to be done, and hopefully the $50 a month really compensates you for the type of work that you would have been doing and asking for $300 a shot, every time you filed a motion or something like that. So I just wanted to let you know those changes are coming down the pike, and what will probably happen is that when the new model plan goes into effect, which should be in the next 30 to 45 days or so, then the new fee structure will go into effect as well. So I hope that's good news for all of you. One little piece of bad news is that $50 monitoring fee is also supposed to include postage and mailing expenses, so you're not asking for additional photocopy charges and postage expenses. On the other hand, If you need to file a fee application, file a fee application, and you can be compensated for that at that time. So just wanted to let you know that those changes are kind of coming down the pike and to be open for them. And when you see the model plan posted for public comment, please feel free to shoot me an email if you have any suggestions for any changes. The other thing to be aware of is we have some mild, slight revisions to the local rules go into effect July 1st. They've all been posted. They already went through the public comment period. I was really kind of excited today. Today I had in a Chapter 7 case, a motion to appoint a debtor's son as guardian ad litem or next friend in the case. And the attorney, who I had never seen before, actually said, oh, she was complying with the new local rule. I'm like, all right, it's not even effective yet, but it works. So that was great. Even better than that is that Stephen Wilkes from the U.S. Trustee's Office was appearing from Tampa. Luis Rivera was on the phone. The U.S. Trustee's Office and the Chapter 7 Trustee's Office had no objection. So that's like the a perfect world. So that local rule, which I'm forgetting the number now, I think it's 1007-1, something like that. That local rule really sets up the procedure for filing a motion like that, and I think that'll make life a little bit easier for those of you who have some of your clients who maybe have problems that they need to have spouses or children help them with. Okay, next I want to move on to the introductions. Before I talk about Cheryl, I just want to introduce you all who have met Kathy Dietz before. I told Kathy Dietz she should have like a badge because she's officially the deputy in charge of Tampa and Orlando and Fort Myers. So deputy, it sounds like she's law enforcement or something. But anyway, Kathy really does a great job. If you have issues, feel free to reach out to her, but she really does a great job. And whenever I have questions, that's my number one go-to person. So now I'll tell you about Cheryl Loesch. I think you all have probably heard me tell the story before about how when I became a judge, I realized how clueless I was about the work of the court. I had no idea. And I think you've heard me tell the story of, from my perspective, I filed a case, hearings got set, I filed a motion, I went to court. After the hearing, I submitted an order, the order got entered, and I thought I was doing all the work. I did not realize the infrastructure that was behind the judge sitting on the bench, and I didn't realize how many people it takes to get the judge sitting on the bench every day. It was just absolutely eye-opening to me. The other thing that was really surprising to me, and I think I've said this to you all before, is, and I think I've asked some of you before, have you ever heard of the AO? Do you have any idea what the AO is? I'm like, we have to get something from the AO. I'm like, the AO? What is the AO? I'd never heard of the AO. The AO is the Administrative Office of the United States Courts, which is where Leanne Bennett is now. She's now number 2 at the AO. And anyway, they're in Washington, D.C. They have 1,000 employees, and they administer the United States courts. I had no idea that they were there. So it was just very eye-opening to me. The other thing that was eye-opening to me, and this will be a little foreign to you all since you're not in Tampa, but the clerk's office in Tampa was on the 5th floor, and right after I got appointed, somebody said, well, you need to go up to Human Resources on the 16th floor. I'm like, 16th floor? What's on the 16th floor? Oh, there's a whole clerk's office on the 16th floor. The Middle District of Florida's clerk's offices were on the 16th floor. I had no idea. I had no idea of the infrastructure. So we were dealt a little bit of a blow when Leanne accepted an offer and an appointment by the Chief Justice of the United States Supreme Court to take the, Deputy Director of the AO, a very, very important job. Obviously a huge loss to us that Leanne was going up there, but she's done a fabulous job with us, and it's a great opportunity, and it's like absolutely inconceivable that a bankruptcy clerk of court would be appointed to that position, and now there's somebody that's at the AO that knows how to lobby for the work that we do and how important our jobs are, so it's really kind of a win-win for us, although a little bit of a loss because we certainly miss her. And she certainly did a great job. So a job opening was posted, and lo and behold, Cheryl Loesch, who had been the district court clerk for the last 17 years, decided she was ready for a little change of pace, and she decided to apply for the position. So just as I was starting to tell you about all the stuff that goes on behind the scenes, in your minds, you're probably thinking, well, a district court clerk, she doesn't know bankruptcy, she doesn't know our laws, she doesn't know our procedures, she doesn't know our rules. And I'm here to tell you, it's about 5% of the job, if that, because so much of the work is beyond the scenes. So for example, there's a human resources department. There's a lot of personnel issues that need to be dealt with. I think we have, 100 and something employees now, 110 down from 170 or 185 in the heyday. But 110 employees spread out among 4 divisions. There's a finance department. I never thought about this, but every time somebody buys a pen and it's bought in the federal government, it's a major issue. There's a lot involved, and you all know, particularly in the days of declining filings, how much you've had to make adjustments within your offices and look at budgeting and looking at forecasts. And the economics of running the clerk's office are a huge part of the job. Maybe it's 50%. I can't even begin to tell you. Especially in those years, a few years ago, where there were, was the government going to shut down? Was there going to be a continuing resolution? Were we all, critical employees? Were we going to keep working? Are our budgets going to be cut? Because our budgets have been cut. They've been cut significantly. And every time there's a budget cut, there's a change to what is called the staffing formula. The clerk of court and her staff have to go back and they have to analyze, are we going to have enough money to make payroll? And sadly, there are districts in this country where they have not had money to make payroll. That has not been our problem, and that's because Leanne and whoever has been our chief judge has been a very careful steward of our funds. And Cheryl has all that experience from the district court. And one of the benefits that we had with Leanne was that she had been on various AO committees and different judicial committees, and so she knew all the people in Washington, D.C. Well, Cheryl knows all the people in Washington, D.C., so that's been really great. So Cheryl is having a lot of fun learning about all of our crazy procedures. She's glad to see that our judges can get on the same page every once in a while and agree to do things the same way. But I just want to kind of assure everybody, it's not like a new job to her, because the basics of the job, the finance, the purchasing, the space and facilities, the technology, all that sort of work has all been happening behind the scenes. And for the most part, I think even we judges are probably oblivious to a lot of it, and I'm sure that the lawyers are probably oblivious to a lot of it as well. So Cheryl brings with us 17 years of really top-notch experience, plus that was with the Middle District of Florida. She was a assistant clerk, can't remember, a chief deputy of, was it Kansas? In Kansas, so she has a lot of experience with the federal government, and we are just delighted to have her with us. So Cheryl, if you'd like to come up and say a few words.
Thank you. It is so nice to be here. I'm so happy to get around to the 4 divisions and meet the bar. Since I started, I think I'm in my 2nd month now, and it's just been such a refreshing change for me. And everybody has been so welcoming and so nice. The judges, the staff in the clerk's office, as well as the bars and all the divisions of the court. And as Judge Delano said, I've been with my whole frame of my whole federal court career has been in the district court side. I'm in my 29th year of working with the district court. I started out as the deputy in charge with what Kathy is. I was like a deputy in the Jacksonville division of the district court here in the Middle District of Florida. And I was there for 7 years, and I did a lot of training for the Federal Judicial Center. I had the opportunity and the honor to fly around the country to help courts do leadership training and initiatives like that. And I even one time got to go to the court in Hawaii, which is quite the coup, and it was very, very fun. And then I took a promotional opportunity with the district court in Kansas, which people would say, why would you leave Jacksonville, Florida for Kansas? And it was one of the best career moves I ever could make. The District of Kansas at the time, and it still is, was very, very on the cutting edge of technology, new initiatives. And part of that was because they were small and they had the time. And this was back in the days when the courts, both the federal court and the district court and the bankruptcy courts, were flush with funding, with resources. So there were resources to devote to initiatives to get efficiencies in place and that sort of thing. So it was really a great experience to go work for the court in Kansas, and I was there for almost 4 years when some of the district judges from Middle Florida called me. The clerk had left, and they asked me to come back, or not, they couldn't make that decision, but they asked me to apply to become the clerk. So I applied and had the honor of being selected, and that's where I served for the last 17 years. So, but it's a great opportunity for me to join the bankruptcy court at this time. It's so refreshing to see the collegiality among the judges and the relationship that the judges have with the bar. It's just, refreshing is the only word that comes to mind. So I look forward to getting to know all of you better and working with you and trying to learn the bankruptcy procedures. And it is actually like speaking a foreign language, I will tell you that. But I'm slowly but surely getting a handle on all that. And it's just due in part with the great staff that Leanne had assembled and had left in place. So Leanne and I were longtime friends. We both started our careers with the federal courts in Jacksonville. So she and I worked out together. We ran the bridges in Jacksonville together at lunchtime. So I was really thrilled for her when she got this opportunity to go to the administrative office, because number one, she's a great loss to our court, but I guess we weigh that with the benefit of having a great leader who understands us in Washington, where they're making a lot of decisions, where they have a tendency to cookie cutter all the courts. And our court here in the Middle District of Florida is one of the largest bankruptcy courts in the country, and the AO tends to treat all courts the same. When they think they treat you as you're in one building and manageable. This court is spread out. There's a lot of geographic dynamics, so it's really to our benefit to have Leanne at the AO, and she's very much enjoying this new challenge. I talk to her regularly, and I've seen her. She's been home a couple times, and she's doing well. She likes where she lives, and she's really happy. But it is a challenge. I can't even imagine, because I feel challenged with all the you take a job that you're familiar with. In our jobs as clerks, regardless of what court you're in, never a day is the same, and that's part of one of the challenges that I enjoyed. Was every day you could go into work thinking, oh, I'm going to do X, Y, and Z, and all these things would happen, and you had challenges that kept it very interesting, and you never quite felt like you knew everything, but you felt like you had a handle on it. So then when you change jobs, it's like what Leanne has done and what I've done, you feel so inadequate in many ways, because there's this whole aspect about your job that you don't yet really understand or know. But it's good to learn new things, and I'm looking forward to that. And so kind of the big part of my career was in the district court, but now I'm so excited to learn new things in the bankruptcy court. And I prefer to look at this as like I've gone to the good side of the court system for this second phase of my career. So thank you all for being so welcoming, and if you need anything from the clerk's office, of course Kathy is the deputy in charge, but don't ever hesitate to call me, and I look forward to seeing you at meetings down the road. So thank you all very much.
I think that it's kind of a short little presentation today, but I'm happy to take any questions if any of you have any questions about anything, and I'm sure Cheryl will be happy, and Kathy, to take any questions if you have any suggestions or issues that you don't mind shouting about in public. So anybody have any questions? No? All right then. Well, thank you. And thank you, Ryan, my new best friend, Ryan. Thank you, Ryan, for pulling this all together. It was really very nice. Okay, well, great.
I think Greg's going to do a case update.
Oh, good.
So.
All right.
All right. Yeah.
And what I'd like to begin with is just echoing and amplifying the judge's comments, welcoming Cheryl to the court, and we look forward to having you around and using you as a resource and relying on your expertise. So welcome you and look forward to working with you in the future. Ryan had asked me just to do a couple of comments on some cases that are recent and relevant, and you might want to take a look at them if you haven't already. One is an 11th Circuit opinion that was issued yesterday. It's in re Pulitzer. And it came out on, well, it's an appeal from a Southern District of Florida bankruptcy case. And it takes the position of whether, when you convert a case from Chapter 13 to Chapter 7, whether the means test is applicable. And there was some case law developed in this jurisdiction. Judge Williamson had an opinion. I think there might have been several other opinions by other judges that stated when you take a look at the contextual reading of 707B, that the means test isn't applicable because it's not a case filed under this chapter. And I think that when Judge Williamson delivered his opinion, that's what he really focused on. However, the 11th Circuit had a different reading, and they went back and they went through their own textual analysis, and they found ways to distinguish how conversion from 13 to a 7 would mandate the use of a means test. I think if you take a look at it from a practical position, Judge Williamson's opinion, although they say you didn't have to do the 707B analysis, they left open 707A, contesting a case under the totality of the circumstances anyway. So from a practical standpoint, I don't think it puts you in any different position other than the fact that you need to complete the means test and do a diligent job with it when you do convert a case from 13 to a 7. Judge?
And just to add to that, Judge Williamson's ruling, which I had followed, was that you didn't need 707B to help you or help the court or the trustee with a fraudulent case, that you could use 105. And that was the basis of Judge Williamson's ruling. Judge McEwen had disagreed with Judge Williamson. She didn't have a published opinion. I think she just had an order, but she viewed it differently. And the 11th Circuit's opinion is really kind of interesting because it said both textual analyses were correct. They were perfectly defensible, but the 11th Circuit went Judge McEwen's way, so she's really happy.
Richard?
What date do you measure the 707, the means test from? The original date of filing or the date of conversion?
I believe it would have to be the date of conversion, although I think that still probably has to be vetted out. I would think if they want a true position of whether the case belongs in 7 or 13, the most sense would be to file a conversion means test, but I'm not sure how the judges are going to rule on that. I think they might relate back to the date of filing in the 6 months prior where you generate that income. I think that is yet to be determined. And if you want to take a look at the analysis both ways, as I said, the case is in re Pulitzer, Pollitzer, just came down yesterday from the 11th Circuit, and Judge Williamson's opinion was in re Layton, Layton, and I can get you the site on that one later if you wanted to. A couple of other interesting notes that you just might want to note for your file and for your practice. Is that the Supreme Court recently came down with a affirmation of the Fourth Circuit in the Henson v. Santander case. And if you recall, that was the case, it was a FDCPA violation against Santander, where the 11th Circuit ruled that there was not standing to bring the FDCPA case against Santander because they weren't a debt collector. And they went through the statute, which is 15 U.S.C. 1692A6, to determine what is a debt collector and what's not a debt collector for purposes of the Fair Debt Collection Practices Act. They made a distinction because Santander was a creditor. They weren't a third-party debt collector. And the Fourth Circuit ruled according to that distinction, and the Supreme Court back on the 12th of June affirmed the Fourth Circuit opinion, basically relying on the same kind of rationale and the same kind of language. So if you have an FDCPA violation and you're considering bringing an action against a debt collector, make sure they're in fact a debt collector and they're not the actual creditor in the case.
And I think with Santander, might have been, it had purchased the debt. That was
did.
the issue. So it's somebody that's purchasing the debt. Of course, they're purchasing it to collect it, but that's another issue.
Right. And I think it might be a distinction without reason, I think if you really look at the true nature behind the FDCPA, that it was going specifically after those types of collections. But the Supreme Court and the 11th and the Fourth Circuit ruled different.
Was the debt default when they took it over?
It was.
Because I thought that was.
Yeah. Well, that was one of the things that they had brought up in the underlying Fourth Circuit opinion, and the court kind of disposed of that analysis and really kind of focused in on whether you're the creditor or whether you're a different entity, which, like I said, I think is a distinction without really reason. But unfortunately, we got to follow the analysis. The final case that I just want to bring to your attention, and I know we got a little bit of time left, is a case from the 11th Circuit, from the 3rd Circuit that was decided on June 1. And it applies to Chapter 13 cases. And it basically holds that even if you haven't funded your Chapter 13 plan by the 60th month, that the court has discretion to give you some type of leeway to fund your plan. Now, what the court does is they narrow it down to very insular and discrete circumstances. But if this ever happens and you run up against it, and I'm not sure it would happen in our district and division anyway. I think we've got a close enough relationship with the trustee's office that they give you enough lead time if your plan was underfunded. But the circumstances that happened here were debtors had filed a Chapter 13 plan. At some point during the administration of the plan, there was a notice of mortgage payment change. And those of us who practice frequently in Chapter 13 realize that's a common problem. These mortgages adjust either for escrow or for interest rate. So ultimately, the plan adjusts. And over time, I don't know whether the debtors were responsible to file an amended plan or the trustees in that division would recalculate. But for whatever reason, they got to the end of the 60 months, and they were, I think, $1,300 behind or so. The trustee at that point issued a motion to dismiss the case, and the trustee's office issued something akin to our conditional order, which said if you paid the remaining $1,300 in the next 15 days, then they would withdraw their motion. Problem is there was a big aggrieved unsecured creditor. And they took the position that if you don't have it funded by the 60th payment, then you're not entitled to your plan consummation and the entry of the discharge in your case. The one good thing that the court did is that they allowed the court some deference in granting the debtors a little bit of time to go ahead and to finish the plan. And they also provided some direction to the courts going forward of those things that you might look to as far as indicia of whether this was appropriate to extend out some type of grace period to the debtors. And if you just bear with me a second here, they really kind of focused in on 4 factors. The first factor was how much longer is it going to take to complete the plan? Obviously, if it's going to take another 6 months, if it's going to take even another 3 months, that might be outside reasonableness. The second is has the debtor been diligently making plan payments? Well, in this jurisdiction at least, you better be diligently making plan payments or your case isn't going very, very far. They also look at how much time has elapsed since confirmation before dismissal is sought. And then finally, if the plan cannot be completed on time due to a large pre-petition claim, was the debtor culpable in failing to properly schedule the claim? So those are the types of factors that they'll take a look at. Obviously, you want all of your plans funded timely, but I could see, particularly with the notice of mortgage payment change, nobody's perfect. And if the trustee doesn't recalculate and you get to the end of the plan and you got a difficult creditor, you might want to use this kind of analysis. Richard?
Did they modify either the allowed plan or the confirmed plan or the order confirming plan in either one of those?
The opinion doesn't tell us.
And how did they get to an underfunded plan if you followed the order confirming plan or the confirmed plan?
All I know is that there was a notice of mortgage payment change that affected the distribution scheme. I don't know how they deal with the recalculation of plan payments in this jurisdiction, Richard. I would presume that it was probably a jurisdiction like ours, where the trustees will adjust the payments as they go forward. God bless you. Every time there's, every time there's an adjustment from a notice of mortgage payment change, we're not responsible to file it. God bless you. To file a new modified plan or amended plan. So I got a feeling it's probably that kind of jurisdiction.
That's in our order confirming.
Excuse me?
That's in the order confirming.
Yes.
It's permitted in the order confirming.
Right.
So in other words, the trustee didn't tell the debtor that there was an increase that was necessary.
Or there was some kind of shortfall somewhere. Like I said, it doesn't get into that factually specific, but I'm assuming that that's probably the case. The other case that Ryan just wanted me to touch, oh, I'm sorry, go ahead.
What was that case name?
This is, I'm sorry about that. This is Klaas, Klaas v. Chauvin, Shovlin, Third Circuit, opinion issued June 1, and I can get you the sites later if you need. Just shoot me an email. I'll be glad to get it for you. I think Ryan had asked me to talk a little bit about Scanlon, going back, and I think the reason why he wanted me to just give a quick refresher on that is because the new local rule changes the order to be in compliance with Scanlon. Is that one of the changes to the new local rules? The order on a Chapter 20
Right,
strip,
yes.
we now take out the language effective upon discharge?
Right, right. A lien strip is no longer effective upon discharge, it's effective upon completion of plan payments.
And if you all remember, this is an older case, so we've been dealing with it for a while. This was the Chapter 20 scenario where you had a Chapter 7 debtor filed a Chapter 13 but wasn't entitled to a discharge because they filed it within the 4 years of the discharge of the Chapter 7. Judge Williamson issued a detailed analysis, kind of went through all of the precedent beforehand, Johnson, went through Dewsnip and Timms, went through Tanner, and came up with the analysis that in a Chapter 13, subsequent to a Chapter 7 filing, you still have the ability to strip a wholly unsecured second mortgage because 1325A5 isn't implicated. You're going by 506 and then 1322. Richard?
Does the trustee file a completion of plan payments on the docket?
I would think they do, yeah. I've seen that in cases that I've had.
Because otherwise, how do you take the order stripping with the discharge? You can take the discharge order and the order stripping and file them a public record.
I think what you, right.
The second mortgage.
I think what you do is you take the either completion of plan payments or whatever order, well, I think that would be the only order
Right,
entered in the case.
I think it's the completion of plan payments, and I will tell you, Judge Gentleman took the lead on redrafting sample lien strip motions and orders, and it's bogged down because there's been a little disagreement among the judges regarding some of the language. So those should be resolved soon, and proposals should be put out there, should be posted on the website. But I think that one of the issues is when do you record your lien strip order? I think some attorneys like to record the lien strip order as soon as it's obtained, and I think that it's now being drafted in a way that you would record the lien strip order plus a notice of completion of plan payments.
Together after
Right.
the plan payments.
Right.
Anything else? Those are all the cases that I had today to talk about. If anything new comes up, I can circulate it around. I can send it to Ryan. He can shoot it around. He always keeps us on top of things and informed. Other than that, that's all I have.
Our next meeting will be on July 27th. We're having a mortgage modification mediator come and speak about some of the pitfalls and give some tips on that. So thank you, everyone.